AI and copyright are colliding again, and this time the UK High Court just made a ruling that could reshape the way we think about training AI models. I'm Sarah Gibson, a college professor and an AI strategist, and I help educators put AI into action. So let's start with the basics. Getty Images, the giant photo library, sued Stability AI, the company behind Stable Diffusion. It's one of the most popular image generators. Getty claimed that Stable AI used millions of its copyrighted photos to train their models without permission, and that some of the AI generated images even reproduce part of Getty's photos or watermarks. That is a serious claim. If true, it could mean that every AI company training on copyrighted data could owe massive royalties. But the UK High Court didn't see it that way. Judge Joanna Smith ruled that training the AI model on copyrighted works doesn't necessarily mean copying those works is in the legal sense. The model doesn't store or reproduce the original images. It really just learns from the patterns like color and composition and texture, but it doesn't keep the original outputs. Think of it like this. This is my analogy, not the court's. Photocopying a Monet painting versus learning to paint like Monet. So the court said, in essence, this is not duplication. And under UK copyright law, if you're not making a copy, you're not infringing on copyright. Now, here's where it gets interesting. The UK doesn't have fair use like we do in the US. It uses a much narrower fair dealings exception. In this case, the judge didn't apply fair use. She found that on the evidence, the model didn't store or reproduce Getty's images, so no infringing copy was made under UK law. It learned on the same underlying idea of transformativeness. If what you're doing creates something new with a new purpose, and it's not replacing the original, that use may not be infringement. Training on AI models transforms data into something new, fundamentally new. It's a model basically capable of generating its own images, not a model generating your images. So what does this mean moving forward? For now, it's a big win for AI developers in the UK. It suggests that training a model on copyrighted data may be lawful if the model doesn't reproduce those works directly. But it's not a blank check. If a model does spit out an image that's nearly identical to a copyrighted photo, or if it stores that works internally, that could still be a problem. And remember, this is a UK ruling. The United States, the European Union, they could rule differently, and likely they will. This case is way more than just about images. It's really about the future of learning systems. Just like humans learn by studying books and arts and film, AI systems learn from data. So here's the question. When does learning become copying? This ruling nudges us towards seeing AI training as transformative learning rather than theft, at least under UK law for now. So here's the takeaway. Training on copyrighted works isn't automatically illegal, but the debate over where to draw the line is so far from over. Pay attention to these cases. They're shaping what's possible next, because as the ruling reminds us, how AI learns may end up being just as important as what it creates.